Hi, everyone. Give me just 1 second while I get everything set up for my various lives. We will get going here in just a second. Hi, everyone. I'm here today to do a live about temporary orders hearings in Texas. So let's get started. First of all, what is a temporary orders hearing and when might that be something you have to deal with? If you have a divorce case, a child custody case, or a custody modification case, it is a very good possibility that you might have a temporary orders hearing. Temporary orders are going to deal with anything that needs to be dealt with urgently before a final trial. They can also kind of set forth the status quo for what's going to happen in your case between now and whenever you get to a final trial. That could be a final settlement, a final trial, but the temporary orders are going to get you from here to there. I have some questions I'll go through to kind of help explain what temporary orders hearings look like, how they work, what to expect. So, temporary orders can often shape your case for a final trial in a variety of ways. If you have a temporary orders hearing that deals with custody and a judge gives you a particular schedule, could be a standard possession schedule, could be 50-50, could be something else, that is going to give you a trial run for what that schedule looks like. Does that schedule work? And if you get to a final trial and the judge sees that the schedule did in fact work and everything seems to be going well with your children, the odds are probably pretty high that if somebody wants that schedule to stay, it's going to stay. It can also show that a schedule does not work. So, for example, you really want to be the primary parent, the other parent fights for 50-50, even though they've really never been that involved or they're not a great parent or whatever. Judge gives them 50-50 at temporary orders, and your child's grades take a nosedive, or your child starts getting into trouble at school, or there are any number of other things going wrong. You can point to that schedule and say, see, judge, 50-50 didn't work. This child was really struggling on the other parent's time. And I think you should switch it to make me primary and make the other parent have standard possession or some other type of schedule. There are also things you can request during a temporary orders hearing that can end up being really important evidence in a final trial, particularly if we're talking about custody. Does somebody need a psychological evaluation? Does someone need an alcohol evaluation? Does someone need to be regularly tested for alcohol with SoberLink? Do we need a child custody evaluation? We can request those things in temporary orders. You may or may not get them, but that's your chance usually to request them. And that can give you a lot of evidence to either settle your case or use in a final trial. One of the things about temporary orders that is going to be very county and sometimes even judge specific is the amount of time that a court is going to give you for that hearing. In Collin County, you get 20 minutes aside, no exceptions. If there are exceptions, I've never seen one. A lot of judges will put the 20 minutes on the clock on the big screen and you watch it tick down, and when it runs out, that's it. Some counties will give you a half day. Some might even give you a full day. I've heard of counties out there that will give more than a full day for certain types of temporary orders. And the amount of time that you're given is really going to impact what kinds of evidence you can use, how many witnesses you can call, things like that. But for the most part, in the DFW area, in the counties where I practice, we do see relatively short time limits for temporary orders hearings. So what does that mean? Usually that means we are going to be limited in the witnesses we can call. We're going to be limited in what type of evidence we can use. If you have a 5-minute long video or audio recording that you think is just going to make or break your case, it is going to be really hard to use up 5 minutes of our time on that one video. we'll have to really, it must be the absolute silver bullet of all silver bullets for it to be worth using a lengthy video as evidence. Most temporary orders hearings, we're just going to have the two parties testifying because there's simply not time to call another witness. But there are certain situations where I know that witness is the most important person we're going to call. The teacher or the therapist who is going to say that the other parent is a problem or that this child is really struggling or whatever the case may be. Those witnesses can be vital. And we're probably going to call that witness first. We're going to get right to the point. We're going to cut out the background information so that that witness can get it in. Some courts will allow summaries of testimony when time limits are restricted, but you really want an attorney who knows your judge and knows if that's something you're going to be able to get in to try to help get more information in front of the judge before they make a decision. What type of evidence can you use in a temporary orders hearing? It is just like a final trial. The rules of evidence are the same in both. Things need to be admissible. They need to be relevant. You really want to have an attorney that understands those things. When you represent yourself, you're held to the same standard as an attorney, and that can make it incredibly difficult, if not impossible, for a lot of people to get those important exhibits in. Common exhibits that we use are social media posts or text message exchanges between the parties. We'll do that a lot. Sometimes there may be school records that are important. There's a lot of different types of evidence. I'd say the most common are going to be text messages, things like that. What about objections? How to handle that? You're on the stand, your lawyer has asked you questions, and the other side objects. If there's an objection, you want to stop talking, wait for the judge to rule. If it is sustained, you just stop talking, and your lawyer is going to move on to the next question. If it's overruled, you can continue with your answer. One question that has come in is, how soon can you get a temporary orders hearing? This is going to vary from court to court, judge to judge. Sometimes we can get in within 4 to 6 weeks. Sometimes it's going to be 4 to 6 months. And that can be incredibly frustrating because, these things are important and you need to know what's happening with the kids. You need to know who's going to pay the bills. If you landed in a county where you can't get a temporary orders hearing for a really long time, you may want to consider a private judge who can hear it quicker. You may want to consider going to a mediation to get temporary orders if you can't get to a final agreement, to get you something quicker than you're going to be able to get from your particular court. You can get in quicker if you have grounds for some type of an emergency hearing. To getting a temporary restraining order, those are only good for up to 14 days. So the court is going to have to give you a hearing within 14 days. Now, do you have the facts to justify getting a temporary restraining order? That is another issue completely. We most often think about temporary restraining orders when we have some sort of danger. We have domestic violence. We have someone who just wrecked their car with a DUI. We have someone who is doing drugs. When we have those kind of emergencies, and usually they need to be relatively recent in order to get a temporary restraining order, then we request those. There can also be financial emergencies that justify getting a temporary restraining order. Someone just moved all the money. Someone spent all the money. Any wide variety of things can get you a restraining order. But if you think you might have something, the quicker you request it, the better your chances. And definitely your lawyer should give you good advice about whether or not it is worth trying to get a temporary restraining order in your particular situation. Another question that came in was, can I get the judge to change the temporary orders later? Sometimes yes, sometimes no. It depends. If there's an emergency, then you can request a temporary restraining order, get a hearing, things might get changed. If there is not an emergency. Some courts will hear requests for modified or additional temporary restraining order, or not temporary restraining orders, temporary orders, and some will not. The last question I wanted to answer was, what can I do if the other side isn't following the temporary orders? In that scenario, you can enforce in certain situations. If they are violating an order, you can file an enforcement against them. Depending on what the violation is going to determine what your remedy is. Is it a violation that gets someone thrown in jail? Is it a violation that gets someone to pay your attorney's fees? Is it a violation that gets you makeup time? It really depends on the violation as to what you can do. But bottom line, at the end of the day, if you have a temporary orders hearing, you really are going to want to have an attorney that is familiar with your judge and with your county to have the best chance of getting the result that you want in that hearing. If you're in the DFW, reach out to us. We would be happy to help. Thanks for joining us today, everyone. And I hope you all have a great holiday season.